Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. Today we will discuss about section 502 of BNSS, that is very important topic concerning the power of a criminal court or the court of magistrate to restore the possession of immovable property. So we have to understand the same as far as the practical concept is concerned, as far as theoretical concept is concerned. So everything is important. I request all of you to maintain a proper notebook, and apart from that, I request all of you to maintain the proper bearers so that whatever I am going to convey you could be maintained by you in the recorded format in case you are having any problem or your relative or loved one is having any problem. In that scenario, we could give them a practical solution without any worry or panic. So, first of all, we have to understand the basic concept of section 502 of BNSS. The said section is part and parcel of chapter number 36 of BNSS, which is concerned with disposal of property. It simply says the power to restore the possession of immovable property. Please be noted. So basically, the title itself indicating the intent of said section. There must be a power to be exercised by the criminal court or by the court of magistrate. Number 2, to restore. Number 3, the possession. And number 4, the property must be immovable property. Basically, the said section is entirely having the 4 subsections. Basically, these are rules and regulation, and we have to understand each of them in the practical sense. So first of all, we are going to consider clause number 1 or subsection 1, and we have to study the same in multiple parts. Point number 1 says that when a person is convicted of an offence, so we could say that the conviction is the prime requirement for the application of section 502 of BNSS. It says where a person is convicted of an offence by the use of a criminal force or by showing of force or by criminal intimidation. So basically there must be an offence. Number 2, the person must be convicted and it must be concerned by use of criminal force or by showing of force or by criminal intimidation. The another parameter is that it appears to the court that by use of such force or by showing of that force or by the virtue of criminal intimidation, any person is dispossessed of an immovable property. In that scenario, the court may think fit order that the possession of same be restored to that person. In that scenario, the court may even order for the eviction by force, if required, so that the person who is in the illegal possession of that immovable property could be removed and the concerned property could be restored to the person from whose possession it is taken by using force or by the virtue of criminal intimidation. Now we are coming on the proviso. That is one of the most important point in favor of defense. That says no such order shall be made. It is imperative by the criminal court more than 1 month after the date of conviction. So if there is a conviction and after a period of 1 month the said order is passed, in that scenario the order sheet or proceeding would be illegal and you may challenge the same on that point. So whenever you are getting a notice from the concerned court as per the protocol of section 502 subclause 1 of BNSS, or apart from that any ex parte order is passed, means without hearing your client, and it is shown that the order is passed after 1 month from date of conviction, in that scenario you may challenge the proceeding or the consent impugn order on that count as well. Now we are coming on rule number 2, means subsection 2. It simply says when the court trying the offence has not made any order, there might be a possibility under subsection 1. In that scenario, the court of appeal number 1 or the court of confirmation number 2 or the court of revision may, if things fit, may make such order while disposing of the appeal, reference or revision as the case may be. So basically we could say that section 502 is nothing but a toothless tiger. The court might incline the remedy. It is not imperative. If the court thinks fit, the discretion is not to be applied, in that scenario the plea could be rejected as well. So I think that defense appearing to be on dominant side as far as the proviso, as far as subclause number 2 is concerned. Now we are coming on point number 3. It simply says where an order is made, the provision of section 500 shall be applicable as they are applicable concerning an order under section 499 of BNSS. So basically if there is any order against your client, you may apply to the consent court of appeal as per the protocol of section 500 of BNSS. In that scenario, you may accompany the said petitions with the stay application, and if stay is granted in that scenario, the execution would be ipso facto. State in that scenario, you could have the effective remedy for your client as well. So basically, we have to understand section 502 subclause 1 subclause 2 in light of subclause 3 as well. So even though the concerned victim is having the order in his favor, but we are also having the remedy as per clause number 3. So for this, we have to apply as per the protocol of section 500 as well as section 502 subclause 3 of BNSS. And last rule, that is subsection 4, says that no order made under this section shall prejudice any right or interest to or in such immovable property which any person may be able to establish in a civil suit. So basically, if there is a civil suit which is pending concerning the property, in that scenario, no order can be made. So whenever the court is going to make such order and a civil suit is pending, you may make the objection as per section 502 subclause 4 of BNSS. So basically, we could say that the rights are available to the victim, but it is not an easy task to get the right, because entire thing depend upon the discretion of the court, and apart from that, the proviso attached with subclause 1, and apart from that, subclause number 4 is going to provide the effective remedy to the concerned accused. So basically, whenever we are going to contest the concerned application or the concern order, we have to understand the proviso attached with clause number 1 and clause number 4 attached to section 502. So I think that I'm totally able to enlighten all of you about the subject in theoretical and in the practical way. See you in the next video. Till then, Jai Hind, Jai Bharat.